Hello and good afternoon, everyone, and thank you very much for logging in for today's webinar on the benefits of a well-run accident benefit file. My name is Keith Gallup. I'll be moderating today's presentation. This is the latest in a regular series of insurance law webinars presented by Kelly Santini, and we're so glad so many of you could log in to join us today. We have quite a few people returning who participated in some of our past ones, but also very pleased to welcome a number of people joining us for the first time. Also understand a number of people affected by the storms yesterday in Toronto and who aren't able to join us. And we're also fortunate that our internet at Kelly Santini kicked back in about 6 minutes ago after it went down at 12:02. So fingers crossed it will stay with us for the next 45 minutes. This is a 45-minute webinar, and we'll reserve a bit of time towards the end to answer any questions you may have. And as the session continues, please do use the dialog box on your screens to send in questions that Sylvia and Scarlett will address at the conclusion of the webinar. And also at the conclusion, as you log off, a very short questionnaire will pop up on screen, just your opportunity to give us some feedback on how we're doing on these webinars, as well as make any suggestions for topics or improvements for future webinars. Our presenters today, we have Sylvia Corthorn and Scarlett Porter, both from the insurance group at Kelly Santini, who are making their webinar debuts. So we're very pleased to have them talking and presenting on accident benefits today. Sylvia is a partner in the insurance group and has over 25 years experience acting for insurers and claimants on AB files, as well as other personal injury, motor vehicle, and medical and other professional negligence matters. And Scarlett is a fluently bilingual associate in the insurance group and her practice has a focus on accident benefit files as well as personal injury and property claims. So that is enough for me. Let me turn things over to Sylvia.
Good afternoon, everybody, and thank you for participating. To those of you in Toronto who've made it to work, congratulations. I wanted to thank Keith for putting this together, and in particular for acceding to the request from Scarlett and I that there not be a webcam on either of us, given that this is our debut. So we have run a number of these previously, and you will have seen from the invitation that the focus of this presentation is on accident benefits matters, and the focus of our discussion will really be on the matter of effective communication in the context of making sure that your accident benefits files are well run. We'll speak about two general topics, the first of which is the gold standard for insurer communication, and that is from the Supreme Court of Canada case Smith and the Cooperators. We'll also speak generally about bad faith claims, and then specifically on two topics. Scarlett will discuss the MIG, and I will discuss insurer examinations. And I want to speak very briefly about that oldie but goodie, Smith versus the Cooperators. It's a 2002 decision from the Supreme Court of Canada, and it's a decision that I always go back to and that I always recommend my clients go back to when they're crafting particularly significant communication with their claimants. I'm certain that you're all familiar with the decision, but I will just briefly review the circumstances in which it arose. It's a case which stems from communication by the insurer with a claimant with respect to the termination of income replacement benefits. And the question which the Supreme Court had to consider was whether the termination of the income replacement benefits had been communicated effectively and had therefore started the running of the 2-year limitation period. Both at the trial level and on appeal to the Ontario Court of Appeal, the plaintiff's claim was barred by reason of the expiration of the limitation period. The Supreme Court allowed the appeal, and what we want to focus on is the outline that the Supreme Court provided as to the style of communication to be used by an insurer when dealing with their claimant. And it's very basic, but as I said, I always go back to it. The Supreme Court recommends using straightforward and clear language directed towards an unsophisticated person. In coming up with that sort of guideline for communication, the Supreme Court emphasized the consumer protection element of automobile insurance. And in rereading the decision again before today, to put together my presentation, I was reminded of, I had forgotten that the Supreme Court went so far as to say that courts are obliged, and that's a pretty strong statement, to impose bright line boundaries between the permissible and the impermissible. So against that backdrop, I'll turn it over to Scarlett, who will talk about the MIG.
All right, so like Tom Cruise in Top Gun, we're going to get up close and personal with the MIG. So as we are all aware, in September of 2010, the provincial government introduced a $3,500 cap on payments for injuries that fall under the new minor injury guideline, which is going to be referred to for the rest of this presentation as the MIG. According to the guideline, a minor injury means a sprain, a strain, whiplash-associated disorder, contusion, abrasion, laceration, or subluxation, and any associated sequelae. So basically, up until March of 2013, there was no decision to help guide insurers and claimants through the interpretation and application of the MIG. However, that changed when arbitrator John Wilson released the first MIG decision in Scarlett versus Belair Insurance Company. The decision has been largely welcomed by plaintiff lawyers, as the decision appears to have provided a roadmap of how to get a claimant out of the MIG. So in Scarlett, the applicant, Lenworth Scarlett, was injured in a motor vehicle accident in 2010. Mr. Scarlett applied for accident benefits, and Belair took the position that Mr. Scarlett sustained minor injuries, thereby invoking the MIG and restricting the scope of his medical and rehabilitation benefits. Scarlett contended that although he suffered strains, sprains, and whiplash-related injuries, he also had pre-existing conditions and subsequent psychological issues which brought him out of the MIG. So, in essence, Mr. Scarlett's attempts to claim certain benefits from Belair were being rebuffed because Belair had taken the position that he was in the MIG. However, even after Mr. Scarlett produced further additional evidence that showed that he had his injuries had become more complex, and he felt that this took his claim out of the MIG, he was still met with the same answer from Belair being, too bad, you're in the MIG. So that leads us to the question of, how do you determine if a claimant is in the MIG or out of the MIG? So in the decision, arbitrator Wilson looked at the burden of proof with respect to the MIG, and he interpreted the guideline as being an exception to the requirement that the insurer pay certain benefits. So in order to come to this conclusion, he looked at relevant case law, notably the Court of Appeal decision of Lozier versus St. Paul Mercury Indemnity Company, and stated that in absence of clear legislative direction to the contrary, exceptions such as the MIG shift the burden of proof onto the insurer to prove on a balance of probabilities that the insured falls within the exception. Therefore, once the insured has satisfied the burden of proving that he or she is insured and has suffered an impairment as a result of the accident, the onus then shifts to the insurer to prove on the balance of probabilities that the insured then comes under the specified exception that would justify non-payment either in part or in full of a benefit. Another important aspect of the decision was arbitrator Wilson stated that In the early stage of the claim process, where the MIG is situated, the insurer is in effect mandated to make an early determination of an insured's entitlement to treatment. But what he's saying, what Arbitrator Wilson is saying, is that even if that's the case, the determination is an interim one that is open to review and can be changed based on updated evidence provided throughout the life of the file. So what kind of evidence is needed? So after analyzing both English and French versions of the guideline, Arbitrator Wilson determined that medical practitioners or stakeholders or other stakeholders must provide credible or convincing evidence if they wish to ensure that an insured be treated as being outside of the MIG. Accordingly, the decision to treat a claimant under the MIG should be made on the basis of credible medical evidence and not on mere speculation. In the case of Scarlett, Arbitrator Wilson found that even those persons who otherwise might be within the MIG can actually be treated outside of the MIG if there is credible medical evidence that a pre-existing condition will prevent the insured from achieving maximal recovery from the minor injury. So Arbitrator Wilson really was advancing the position that the insurer should not be in a position to veto access to benefits on the basis of a delivery of a single report, the insurer's examination report, at an early stage of the claim, especially when they have new credible medical evidence that shows the contrary. So what happens, like in the case of Scarlett, if in the beginning the medical evidence that was provided basically put Scarlett in the MIG, and he was classified as MIG, and then over time the claimant provides additional medical evidence that shows that his conditions have become more complex and actually is out of the MIG. So, and in response to that, the insurer provides their own medical reports that are contrary to what the claimant's new medical reports are. So when we have conflicting credible evidence, Arbitrator Wilson said that this is the sort of conflict that needs to be resolved in a court or by arbitration, on the issue of reasonableness of the proposed treatment plan, and not the unilateral veto of benefits by the insurer. So in conclusion, this decision shows us that with respect to the MIG, it is important to remember that each case merits an open-minded assessment of each claim, and acceptance that some injuries can be complex, even when there are soft tissue injuries present amongst the constellation of injuries arising from the accident. So the decision to treat an insured in the MIG or not in the MIG should be made on the basis of credible medical evidence and not in speculation. That decision can change over time. And also it's important to remember that if a pre-existing condition exists that will prevent the insured from achieving maximal recovery from the minor injury, then that claimant can be treated out of the MIG. Thank you. And I'm going to pass it back to Sylvia.
The final two topics are topics which I'll tackle, and they stem from, in part, my observations over the years of attending and presenting at seminars of this kind. And what I find is that people who are speaking generally speak on topics that fall into one of two categories. It's a topic of particular interest in their field at a particular time, or they're grumpy about something. And so one of the subjects is something I get grumpy about, and that is the first topic that I'll tackle, and that's insurer examinations. In tackling this subject, I want to remind you of the Supreme Court of Canada statement in Smith to the effect that the courts are obliged to impose bright line boundaries as to what is permissible and what is not permissible. And on that subject, I want to address the issue of consent forms on insurer examinations. As Keith mentioned at the beginning, I do both plaintiff's work and I do insurance defense work, including accident benefits. So I do see this topic from both sides of the table over time. And when I'm wearing my claimants counsel hat, for many, many years, I have taken issue with an insurer or an examiner who requires my client to sign a consent form as part of the IE process. And there may be some of you out there, I took a quick look at the list, but I didn't see anybody in particular that I could remember having this battle with, but I may have battled with one or more of you on this subject, and if I have, then what you would have received from me is a letter in which I address the fact that from time to time my clients have faced a request from an examiner to sign a consent form. So I try to deal with this proactively, and I'm sure that there are any number of my colleagues across the province who do the same. So when my clients are asked to attend an IE, I write a letter and I indicate that I need to see a consent form. If one is going to be asked, I need to see it ahead of time, and I need to consider it. And I take that position because when you look at the SABs, there is nothing in the SABs, which is a complete codification of the process, which mandates the use of a consent form. In fact, if you look at the SABs, you'll see that there is, in fact, nothing on consent forms. So the position that I take on behalf of my client is you better let me know if a consent form is required, and if so, my client won't attend unless we can agree on the form of the consent. I also take the position that if my client ends up not attending because we haven't been able to come to some agreement on the consent form, that my client's lack of attendance will not amount to a failure to attend the IE. And I sum my position up by saying the IE will not have been properly constituted within the provisions of the SABs, so there was nothing that my client could fail to attend in the first place. I was quite pleased from my plaintiff's hat perspective to see the decision again of arbitrator Wilson in 2012 in Luther versus Economical Insurance. The issue in that case was whether the refusal by the claimant to sign a consent form for an IE amounted to failure to attend. And I emphasize that on the facts of the case, arbitrator Wilson concluded that the failure of, or the refusal of the claimant to sign the consent form did not amount to failure to attend. What is somewhat concerning, I think, for both insurers and for claimants is that arbitrator Wilson did not make a broad sweeping decision as to whether or not consent forms are required or appropriate generally with respect to insurance exams. And I just want to take a moment to look at the practical considerations of that decision and the issue of consent forms from the perspective of the insurer. I'm quite certain that in 99.9% of the cases, it's not the insurer who is making the request for the consent form. It's either the individual examiner or the umbrella organization under which the examiner works. When they make that request, the examiner is not relying on the SABs. And so I wonder, and I'm sure the insurers wonder, what, if anything, do they have to rely on in making their request? The majority of examiners would fall within the scope of the Healthcare Consent Act. They would be a physician or someone else whose practice is governed by that act. And if you have an opportunity, I would commend you to read the Act, and you will see from your reading of it that there is nothing in the Healthcare Consent Act which requires that, for example, a physician obtain consent in writing. They are required to secure consent, but there is nothing to say that it must be in writing. So if it's not the statute, what else could the examiners rely on? And I've often heard in response to my position, oh, well, my college requires me to get consent. Again, if you look at the requirements from the various colleges, whether it's the physicians and surgeons, it's the College of Occupational Therapy, physiotherapy, whatever, you'll see that, in fact, they do not require that consent absolutely 100% be in writing. The references that are made in the college guidelines are to documenting consent, and that means making a record of it. It would be sufficient, therefore, to document in the notes and records made on the date of the examination that, in fact, you as the examiner have secured the consent of the person to the treatment. And I'm certain that many of you have read tons and tons and tons of medical records over time, and you will have seen in the notes of a physician or in the notes of a nurse obtained consent to whatever it was they were looking for that day. So from a practical perspective, what's the solution for the insurer so that they can move their file along, make sure the insurer examination takes place as scheduled, and not incur costs associated with canceling examinations because issues such as the consent form cannot be worked out? Arbitrator Wilson addresses this in his decision, and he speculates that there is nothing to prevent an insurer from vetting the consent forms before the examination takes place. And I would go further than that, frankly, and suggest that if there is an organization, or if there are a series of organizations that you as insurers turn to for IEs, the umbrella organizations that actually find the physician, schedule the exams, my suggestion would be that you deal with them upfront across the board and get sorted out what it is, if anything, they require by way of a consent form, and perhaps have your counsel review it so that they can assist you in negotiating with the examiners so that you get to a form that is reasonable and likely to be acceptable to most claimants and their counsel. And I make that recommendation on the assumption that the economics of insurer exams is such that there is money to be made by these examiners and by these organizations in conducting these examinations. So surely they will want to be cooperative in a process of that kind. And as I mentioned at the beginning, if this issue isn't worked out, whether it's by way of tackling it on a broad scale with the organization, or immediately upon setting up an appointment with a particular examiner on a particular file, if it doesn't get sorted out well in advance of the date of the examination, then the insurer faces cancellation fees, the accrual of further interest at the end of the day if benefits are ultimately paid. It becomes a costly process. And on this subject, I will conclude by commending to you a paper that was written by Deanna, D-E-A-N-N-A, Gilbert of Thomson Rogers for a CDL, a Canadian Defense Lawyers Accident Benefit Symposium this year in 2013. She does an excellent analysis of the state of the law with respect to the issue of consent. And I'd like to turn now to the subject of bad faith claims. And this discussion falls into the category of a subject matter that's of interest to me. And the topic came to mind, frankly, because of, in part, the decision in Branco versus American Home and Zurich. That's the decision from the Saskatchewan Court of Queen's Bench from March of this year. And if you're not familiar with it by name, I'm certain you're familiar with it by number. the $4.5 million awarded for punitive damages and the $450,000 awarded for aggravated damages. In the early spring of this year, that decision sent shockwaves throughout the insurance industry on its release. And about a week after the news of that decision broke, I was reading the weekly reporting series that lawyers get in Ontario, the Ontario Reports, and I was struck by the contrast on the subject of bad faith in the Ontario Court's decision in Spadafora, that's S-P-A-D-A-F-O-R-A, versus Dominion of Canada. And that's a decision from December of 2012, so it predates Branco by about 3 months. And when I read the decision in Spadafora, I wondered why that decision wasn't more of a focus for insurers, accident benefits insurers in particular, and one which would give some sense of relief in contrast to the sense of panic which the Branco decision was generating at the time. Branco, for those of you who haven't had a chance to read it, in my opinion, has very limited application based on the extremely egregious fact situation, and it also has very limited application because a Saskatchewan case is not binding in Ontario, and perhaps most importantly because the decision is, not surprisingly, under appeal. Spadafora, on the other hand, is not under appeal, and in my opinion, it stands as authority for the proposition that the statutory accident benefit schedule is not a contract of insurance, the purpose of which is to secure a psychological benefit. And that phrasing is the one which the courts rely on when they determine whether or not a particular contract of insurance is a contract of peace of mind. So with Spadafora, you have the court saying the SABS is not a peace of mind contract. So as a result, the insurer at a very early stage of the litigation was able to secure a summary judgment dismissing the claim for damages for mental distress. And the claim for damages for mental distress was in the amount of $1 million, and that was lumped in with the claim for aggravated, punitive, and other forms of damages. But it's a very explicit finding, in my opinion, and one on which insurers may rely on going forward when faced with claims for damages for mental distress. Now, I have no doubt that claimants will continue to bring claims for damages for mental distress, and for the issue to be truly definitively addressed may well require that in another case the decision level reach that of the Ontario Court of Appeal or the Supreme Court of Canada. But for now, from a practical perspective, insurers could be looking at their existing litigation, identifying the claims in which the plaintiffs are advancing a claim for damages for mental distress, and considering whether on Spadafora and other related decisions there isn't a basis for a motion for summary judgment. And I'd recommend that before that step is taken, there may even be sufficient basis to alert plaintiffs' counsel to the decision in Spadafora, if they're not already aware of it, and attempt to secure consent to dismissal of that aspect of the claim. The Spadafora decision also addresses the issue of damages, a claim for damages for bad faith. It does so a little bit less explicitly, in my view. The defendant was also successful in securing an order dismissing the claim for damages based on bad faith conduct. What I think is implicit rather than explicit from the decision is that the denial of entitlement to a benefit, even in the face of some evidence of entitlement, is not sufficient to support a finding of bad faith. to me, that aspect of the decision should give comfort to accident benefits insurers that they can go about the business of receiving, assessing, and responding to claims without concern that denying a claim in and of itself will entitle the claimant to damages for bad faith. Ironically, and frankly entirely unintentionally, the Spatafora decision brings us right back to where we started, and that's the Smith decision. In Spatafora, the facts of the case were that the claimant applied 6.5 years after the accident for payment of a non-earner benefit. The insurer took the position that it had denied on a global basis entitlement to any weekly benefits, including the non-earner benefit, at least 4 years earlier. So what's left to be determined by the court, because the claims for damages for mental distress and for bad faith have been taken off the table, what's left to be determined is whether the denial made at an early stage of the action was sufficient to trigger the running of the limitation period. And reference is made to the decision in Smith, and whether the wording and the form of the denial made that number of years earlier was sufficient to trigger the running of the 2-year limitation period. On the motion for summary judgment, it was determined that that was a genuine issue for trial, and so that aspect of the matter remains to be determined. So at the end of the day, as I said, we're back to where we started, and we've come full circle back to Smith and the actions of Dominion of Canada being scrutinized on the basis of the style of communication which the Supreme Court dictated or mandated as of about 10 or 11 years ago. So here we are back at the beginning.
All right. Thank you, Sylvia. Thank you, Charlotte. We're now going to take some questions. So please type in using the dialog box any questions that you might have and want to ask. Let me just open up our box here, and I will actually start with one that's come in for Charlotte. Charlotte, the question is it possible over the life of a file to go in and out of MIG a number of times?
Well, the decision, the Scarlett decision doesn't answer that question right off the bat, but it does say that it's to be revisited based on the evidence that is provided. So to me, to a certain extent, it would make sense that if evidence was, credible medical evidence was provided by the claimant that they were first in the MIG and then out of the MIG, and then over a period of time their symptoms or conditions went back to being those of in the MIG, then it would make sense based on the decision that they could possibly go back into the MIG.
Okay, thank you. Question in for Sylvia. What are the types of things that you see in consent consents from IE assessors that are cause for concern for you when acting as plaintiff counsel?
That's a great question, and I'm really glad somebody asked it, because I asked my secretary this morning to dig up from some of my files some of the consent forms that I've taken issue with over time, and just even in skimming a few of those, one of the things that I would object to is a release of the examiner, and I'll just read one here. I hereby release examiner, employees, contractors from all claims or liability in regard to any injury, impairment, or disability that may result from me participating in the evaluation, except when caused by gross negligence of the evaluator. I don't think that's appropriate for a claimant to have to release the examiner in advance for any potential harm that might arise. One of the elements of a consent that I frequently see is consent to dissemination of information from my clients treating health professionals to the examiner. That one comes up over and over again, and there's no basis for it based on the SAVs. There are other elements of consent forms and things like where they outline the nature of the examination specifically, and they make broad sweeping statements as to what the examination is intended to address, when in fact it's only intended to address, is the 10-week physiotherapy program reasonable or something like that. So there are lots of different examples, and if the individual who posed that question wants to communicate with me directly, I'm happy to provide a broader answer in due course.
Okay, thank you, Sylvia. We have another question in about MIGs. If a claimant is non-MIG due to concussion symptoms, does a subsequent MVA automatically call for a non-MIG determination even with minor soft tissue injuries?
All right, can you reread that one for me?
If a claimant is non-MIG due to concussion symptoms, does a subsequent MVA automatically call for a non-MIG determination even with minor soft tissue injuries?
Well, I think not necessarily, but I think that what needs to be provided to determine if it is MIG or not is the credible medical evidence, as Arbitrator Wilson had said, to the symptoms, and whether the pre-existing concussion symptoms will prevent the claimant from fully recuperating from the actual the current accident symptoms. Then yes, they would be pulled out of the MIG and treated to that effect.
Okay, and I think we have time for one more question. This one is for Sylvia. As a claimant's counsel, what do you advise your clients to do in the event that they are unexpectedly presented with a consent form on arrival at an IE?
Generally speaking, I will have covered this off with the insurer before my client goes, and I let the insurer know that if this happens, my client's instructions are to attempt to reach me so that I can go over the consent form and attempt with the examiner to negotiate the terms of the consent form, but that if that doesn't happen, my clients will not sign the consent form, and if the examiner is not prepared to go ahead, then the examination can't take place that day. And again, it's not my client failing to attend, it's that the examination hasn't been properly constituted. And I will tell you that on at least 2 occasions I've been somewhere and had a call from a client presented with a form despite all of our best efforts to deal with it ahead of time. And I have found myself on the phone with an examiner negotiating the terms of a form.
Well, thank you very much, Sylvia and Charlotte, and thank you to everyone for spending your lunch hour with us, and thank you to everyone for sending in those questions. If you do have any more questions for Sylvia or Charlotte on accident benefits, or would like a copy of the slides, please do get in touch with them by phone or email. The addresses that you can see up on your screen. We've recorded today's session and will be posted on Kelly Santini's YouTube channel, where all the past insurance law webinars are posted as well. So if you do have any colleagues who unfortunately weren't able to attend today, they'll be able to access that probably starting sometime tomorrow. And just as a conclusion, just a reminder that a short questionnaire will pop up as an opportunity for you to give your feedback as you log off and as we log off. So I think that concludes our session today, and I hope everybody has a very good afternoon.